The lawyer didn't call it a reading, he called it a formality. Regina still sat down like it mattered, because her father used to host Sunday dinners at that same dining table, napkins folded tight, coffee poured before anyone asked, the kind of quiet order you don't notice until it's gone. Now he was gone, and Regina, his youngest daughter, was staring at a manila envelope with a red seal while her older sister Diane sat perfectly still beside it, hands folded, face calm, like this moment had been practiced in private. The lawyer cleared his throat. He read the house to Diane. He read the investment accounts split between Diane and their brother. He read, "No additional beneficiaries." Regina waited for the part where her name would appear. It didn't. For a second, she thought she'd missed it, like grief had muffled a sentence. But the lawyer didn't correct himself. He simply slid the envelope back into his briefcase, as if the absence of her name was the most normal thing in the world. Regina's loss wasn't emotional, it was concrete. She had been left with nothing, and before she could even ask a question, Diane leaned slightly toward her and whispered, almost kindly, "Dad changed his mind." Regina didn't argue at the table, not yet, because she noticed something that made her stomach drop. Diane's calm wasn't relief, it was control. And control usually leaves fingerprints, somewhere. That night, after her siblings left the house talking in low voices like Regina wasn't in the room, she walked into her father's study. The desk still smelled faintly like his aftershave, the bottom drawer stuck the way it always had. Inside, beneath old tax folders and a stack of unused stationery, she found a worn leather binder. One corner was cracked like it had been opened 100 times. Tucked inside was a document, crisp at the edges, signed in blue ink. An earlier version of the will, and on the beneficiary list, clear as daylight, was her name, Regina. Undeniable. She stood there holding it with both hands, as if paper could weigh enough to steady a person. If her father had once included her, then someone had decided she shouldn't be there anymore. Back at the dining table, Regina laid both documents side by side. The structure matched, the legal language matched. The formatting was nearly identical. Only one thing was different: the beneficiary list. Her name wasn't replaced by someone else. It was simply removed. The newer will was dated 8 months earlier. During the same months, her father had started treatment for cognitive decline. Regina didn't accuse Diane. She didn't cry. She did something quieter. She took photos. She zoomed in on signatures. She saved everything into a folder labeled Dad, because silence can last years. But documents outlast silence. The next morning, Regina called the probate clerk to verify when the updated will had been filed. 6 months before his passing, the clerk confirmed. "Do records show who brought him in?" Regina asked. "No companion listed," the clerk said, "but there is a payment receipt attached." When the clerk emailed the receipt, Regina's hand went cold around her phone. The card used to pay the filing fee belonged to Diane. Regina stared at the last 4 digits like they were a confession. Diane hadn't mentioned paying for anything. Why would she pay for a will change, unless she was involved? That night, Regina wasn't grieving money. She was grieving something worse. The years of being kept in the dark, then told, at the end, that she didn't matter enough to be named. Regina requested her father's medical notes for the week the updated will was signed. The neurologist's language was careful and clinical. Mild cognitive impairment observed. Recommendation: supervision for major legal decisions. Supervision. Regina read that line 3 times. If supervision was recommended, then who supervised? And what did they tell him? When she brought it up to Diane casually, like she was asking about a doctor's appointment, Diane's smile didn't move. "You weren't around much then," Diane said softly. It wasn't an argument. It was a cut, dressed as a fact. Regina scheduled a meeting with the lawyer who drafted the earlier will, the one with her name included. He looked at the documents, then at Regina. "I didn't write this updated version," he said. A breath of hope rose in Regina's chest. If the lawyer didn't draft it, maybe it wasn't valid. Then he added, steady and direct, it was signed properly, witnessed, filed. On paper, it's binding. Hope didn't disappear. It stabilized into something colder. If the signature was real, then the question wasn't, did he sign? It was, did he understand what he signed? Back in the study, Regina powered on her father's old desktop. The password took 3 tries. Her hands shook on the keyboard like she was breaking into a life that used to be open to her. In the Documents folder, she found a draft labeled, Will Final Draft. The timestamp was from months before the filing. She opened it. Her name was still included. Then she checked the file history. No edits removing her name, no revisions, no tracked changes, which meant something very specific. The removal didn't happen as a revision of his original draft. Someone introduced an entirely new version. Premeditation doesn't always look like violence. Sometimes it looks like a clean file name and a printed page. Regina requested a certified copy of the filing receipt from probate. It matched the emailed copy exactly. Same date, same fee, same card, Diane's card. When Regina confronted Diane gently, just the receipt on the counter between them, Diane didn't deny it. I was helping Dad, Diane said. Paperwork, you were busy. It sounded reasonable. Too reasonable. Because Diane's whole strategy wasn't shouting, it was framing care, protection, responsibility. And Regina realized something she'd never said out loud before. Diane didn't just step in when their father declined. She had positioned herself as gatekeeper long before that. Regina requested the witness names on the updated will. 2 neighbors. One was Mrs. Holloway, an elderly woman who had known their father for years. Mrs. Holloway frowned when Regina asked about that day. He signed it at the dining table, she said slowly. Diane said it was routine. Routine. Regina asked, did he read it? Mrs. Holloway hesitated. He skimmed. Diane explained it was just an update. An update. Not an exclusion, not a removal. Regina left with the kind of information that isn't proof yet, but is too heavy to ignore. That evening, Regina got her first piece of truth that didn't rely on memory or inference. A voicemail. It came from Diane's number, but it wasn't Diane's voice at first. It was her brother's, low and annoyed, clearly speaking in the same room as Diane. You sure she won't notice? He said. Then Diane, quiet and confident. He didn't notice the difference. That was the point. The voicemail ended with a click, like the phone had been pocketed mid-conversation. They hadn't meant to call her. They hadn't meant to leave evidence. But life leaves evidence anyway, when people get careless. Regina didn't text back. She didn't call Diane screaming. She saved the voicemail, backed it up, emailed it to herself, then to her attorney. Because truth, once heard, cannot be unheard. Regina hired a digital forensic specialist to analyze the electronic version filed with the court. The report didn't bring drama. It brought timestamps. Metadata showed last-minute edits to the will, less than 30 minutes before it was printed and signed. And the specific edit? The deletion of Regina's name. A final cut, minutes before ink touched paper. Regina sat at the kitchen table in her own apartment and stared at the report until her eyes burned. Who makes last-minute edits to a dying man's will? Someone who has access. Someone who thinks proximity equals authority. Regina met Diane privately. No siblings, no audience. She placed 3 things on the table. 1. The certified receipt with Diane's card 2. The neurologist recommendation about supervision. 3. The forensic metadata report. Diane scanned them like a person reading a grocery list. Then she said something that sounded like a defense, until it revealed the truth. I simplified it, Diane said. Dad trusted me. He didn't want complications. For a second, Regina's certainty wavered. What if their father had delegated? What if Diane truly believed she was protecting the estate? Then Diane leaned in and said the sentence that made everything personal. "You always needed help. Dad knew that." Regina didn't respond, because she finally understood the core of it. This wasn't about simplifying, it was about control. And control needs a narrative where Regina is weak enough to be erased. Regina reviewed years of financial records, not in a dramatic montage but line by line. And she found something concrete. A bank form, signed during their father's decline, granting Diane added authorized access to one investment account, dated 2 weeks before the will update. Not illegal by itself, but strategic. A quiet ladder built step by step toward total authority. The updated will wasn't an isolated act. It was the final step in a long, silent progression. Regina met with a probate litigation attorney and laid everything out. The earlier signed will, the medical notes, Mrs. Holloway's statement, the voicemail, the metadata report, and the bank access change. The attorney didn't react emotionally. He reacted structurally. "This isn't about whether he signed," he said. "It's about capacity and undue influence." Undue influence. 2 words that finally matched what Regina had felt for years without language. Regina filed the petition to contest the will quietly. No Facebook posts, no family group chat, just paperwork. 2 weeks later, Diane received formal notice, and her tone changed for the first time. No longer calm, no longer composed. She accused Regina of attacking the family during mourning. But the filing did something powerful. It froze the estate. The house couldn't transfer. Accounts couldn't be divided. Time, which had protected Diane, suddenly turned against her. During mediation, Diane introduced a handwritten note. The room shifted when it was passed around. "Diane will handle everything. She understands what's fair." The handwriting looked like their father's, the paper looked aged. Even Regina felt doubt. For 2 days she wondered if she was the villain in her own story. Then her attorney did something simple. He asked for forensic dating and handwriting analysis. The note was authentic, but it was written 2 years before the will update, before the cognitive decline. It delegated management, not redistribution. Diane had stretched the meaning like a rubber band until it snapped over Regina's name. Under oath, Diane was asked direct questions. "Did you prepare the updated version of the will?" "Yes." "Did you explain to your father that Regina's name had been removed?" A pause. Silence can weigh more than words in a courtroom. "I told him it simplified things," Diane said. "Did you explicitly state she would receive nothing?" Another pause. "No." The air in the room changed, because omission is not clarity, and clarity matters. A neurologist testified. "Mild impairment does not equal incompetence," he said carefully. Then he added the line that mattered. "However, individuals at that stage are highly susceptible to suggestion and framing." Suggestion, framing, the same tools Diane had used at that dining table for years. The digital forensic expert testified next. He displayed the timeline, the original draft, the earlier signed will, then the final version. The removal of Regina's name happened 27 minutes before printing. The timestamp aligned with Diane's laptop credentials. The attorney asked one question that didn't need emotion. Who had physical access to this device at that time? Diane answered quietly, "I did." Truth didn't explode. It settled, heavy in the room. Weeks later, the judge ruled. The updated will had been executed under undue influence during a period of cognitive vulnerability. The earlier signed version, the one Regina found in the leather binder, was reinstated as the valid will. Regina didn't smile. Diane didn't look at her. There was no dramatic apology, no reunion. Because justice in real life is rarely cinematic. It's procedural, but it is real. And the record now reflected what her father had originally intended. When the estate was redistributed, Regina received her lawful share. But what she gained wasn't money. It was something quieter. For years, she believed she had been forgotten by her father. The courtroom proved something else. She hadn't been erased by his love. She had been removed by someone else's control. Months later, Regina walked through her father's empty living room one last time before the property transfer. Sunlight fell across the same dining table where her name had vanished in silence. She took the earlier signed will, the one with her name intact, and placed it back into the leather binder. Not as a symbol of inheritance, but as proof. Proof that silence can last years. But documentation outlasts silence. And sometimes the question that changes everything is simple. Did he even know what they changed before he signed?